Obviously, the jury is not going to be here until 10:30. General Crouch, for planning purposes, you had indicated that you wanted to reserve the closing of the proof, and obviously I want you to have that opportunity to do so
in progress.
In front of the jury, but do you anticipate calling any other witnesses?
No.
All right. So the state will have concluded its proof whenever we bring the jury back in. The next step would be to request whether or not the defense is going to present any sort of proof. And then at that point, depending on whether or not the defendant testifies. So we'll move through that. Let's get the defendant out. Mr. Hopkins is going to be joining us today.
Yes, Your Honor, you stepped out of the hall.
All right, that's fine. All right. One thing that, before we get to the charge, and I appreciated this, I believe it was Mr. Hopkins or Mr. Evans, one had submitted a stipulation that was entered into yesterday. I don't know if I've left the stipulation in the office or not. Do you have the original stipulation? I've got it. Thank you. For the record, the stipulation, which was actually prepared by Assistant District Attorney Wyatt, and it states the following: it comes out of the state of Tennessee through the office of the District Attorney General for the 23rd Judicial District of Tennessee, and submits this stipulation between the state and the defendant, Stephen Wiggins. The state submitted proof through the body camera worn by Sergeant Daniel Baker, wherein the defendant gave Sergeant Baker a fake Social Security number. Since the Social Security number belongs to an actual United States citizen, the state and the defense stipulated to these facts to protect the identity of this individual. The stipulation was announced in open court on August 4th, 2021, and is memorialized in this written stipulation. Is that, in fact, the stipulation entered into by the state of Tennessee?
Yes, sir.
And is it by the defense?
Yes, Your Honor.
All right, thank you. Then we will show that it has been marked as a part of the record. It's been a stipulation that entered into this by the parties. All right. Now, I know that you may not have had a great deal of time to look through the draft of the charge that I have, but let me first address that there were two requests for jury instructions that were submitted by the state and one by the defense. And counsel, the first request for jury instruction number 1, it is the state's request to instruct the following: the elements of premeditation and deliberation may be established by proof of the circumstances surrounding the killing. There are several factors which tend to support the existence of these elements, which include the use of deadly weapon upon an unarmed victim, the particular cruelty of the killing, declarations by the defendant of an intent to kill, evidence of procurement of a weapon, preparations before the killing for concealment of the crime, and calmness immediately after the killing, lack of provocation, and failure to render aid. That was submitted based on the Tennessee Supreme Court's decision in State v. Bland and State v. Finch, which are cited as a part of the motion. The defense responded with their own request for jury instruction number 1, which also deals with premeditation, and it states as following: perhaps the two most oft-repeated propositions with regard to the law of first-degree murder, that the essential ingredient of first-degree murder is premeditation, and that premeditation may be formed in an instant, are only partially accurate, because they are rarely quoted in context. In order to establish first-degree murder, the premeditated killing must also have been done deliberately, that is, with coolness and reflection. Even if intent or purpose to kill and premeditation, design, may be formed in an instant, deliberation requires some period of reflection during which the mind is free from the influence of excitement or passion. Gentlemen, I have considered your request. If you want to state anything further on the record in support of those requested, I'll be glad to hear you. Anything you want to add in addition to what you've written? And I believe that the Tennessee pattern jury instructions that are the standard on premeditation sufficiently address the issue of premeditation for the jury's consideration. I understand the state's instruction tends to support the state's theory in the case. The defense's instruction tends to support, is language supporting. I know this is a great surprise to everyone, that the defense's request tends to support their theory of the case. But I believe that giving both of those instructions would cancel each other out, and I think therefore that the standard pattern instructions will be sufficient. Clearly, you can argue all of those issues in your closing argument to the jury. You can make that very argument to them and point to the facts in the record that you believe support that. But I believe instructing them on that, well, again, if I gave both of them, I would cancel each other out, and I think the standard instruction is sufficient. The second instruction that was requested by the state has to do with flight, evidence of flight, and we had already included in our draft that instruction, so that request is not necessary, but would have been granted had it not already been included. So now that I've given you that instruction, let's run through the draft of our final charge. And then again, we have the jury coming in at 10:30, so we'll need to take up anything else that's hopefully can expedite things once they return. The only thing, we had highlighted a couple of issues, and I will state that Ms. Fry and Ms. Jones have worked both together on this draft, and Ms. Jones has given us invaluable service in helping us to try to make sure that this is correct. First question I want to address is under count 3, where it's first-degree murder and perpetration of a felony crime. Then the killing, and if we look down to paragraph 2, that the killing was committed, these are the elements of the crime. The killing was committed in the perpetration of, or the attempt to perpetrate, the alleged theft of property. Then we normally would include what the theft of property is, and that's which theft are we talking about? If the state...
Yes, we're electing under that to proceed with the Ford Explorer Unit 500.
All right, so the Ford Explorer 500 is the theft of property that you're relying upon for that count?
Yes, sir.
All right. Then we will include that. And let's see if there was another section. And I realize it's only 36 pages long, so I'm sure you had time to quickly run through it, but all right, if you'll move to the language that, and I don't have the pages numbered, when we printed this, the page numbers didn't come out, but when we talk about the proof of any other crime, I had included language, and we highlighted it to ask whether or not you wanted that language included in there. And this language is, if from the proof you found that the defendant has committed a crime other than that for which he is on trial, you may not consider such evidence to prove his disposition to commit such crime as that on trial. And it goes on to give them the standard instructions about considering it for the complete story of the crime or for motive. State have any position about the inclusion of that charge?
We would ask that it be included.
Defense have any question about it? Do you see where I'm talking about, Mr. Evans?
Yeah.
Right, if you need a moment, that's fine. I don't want to rush you, but.
No objection.
All right, so we will include that language as well. And all right, then I believe those are the only issues that we had highlighted on the charge. I did want to give the state an opportunity if there was any objections to the language that in this draft, other than what we've touched on. Is there anything you want to request a change to or modification to that charge?
Not at this point, Your Honor, but I'm on page unknown halfway through.
You have, well, let me just say this. It is now 5 to 10. The jury's going to be here in about 35 minutes, so you've got time to go through it. I'm not trying to rush you. I want to give both sides an opportunity to look at it.
I have this many left to go.
So why don't I take a recess? Was there anything else that we need to address other than the actual charge itself? Well, broadly for both. But.
Your Honor, I'd like to address one issue. Previously, Your Honor had ruled that you were going to reserve judgment for the autopsy photos. We just wanted to put it down on the record that both defense counsel and the state had agreed to these photos and that Your Honor didn't have to rule on them.
All right, that is correct. And it was brought to my attention in chambers that neither side had any objection to the demonstration of those particular photographs. So although I had in a prior pretrial ruling reserved the issue of ruling on the admissibility of those photographs, there was no objection raised and the parties had agreed those photographs that were demonstrated at the trial were agreeable by both sides that they were admissible, so those were admitted. Then I asked the state, let me ask the defense, is there anything, have you had an opportunity to go through the charges or anything additional that you want to request?
No, Your Honor.
All right, then let's take a short recess, and Mr. Crouch, if you will come back and let us know if there's anything you want to change about it, then we'll try to get it. The reason I'm wanting to do that is I would like very much to, when the jury is here, go ahead and let you close your proof, then I'll have to send them out. We'll do the Momon hearing with the defense, and then we'll, after that, we'll bring the jury back in, let the defendant close its proof, and then we'll go directly into closing arguments. Any reason that can't proceed like that? All right. Then I would like to have the 16 charges, copies of the charge for all of the jurors along with the verdict form that we have drafted. Have you seen the verdict form that we've drafted?
Your Honor, we saw a glimpse of it last night, but we don't have a copy of it yet.
We'll give you a copy of it, so.
And just for planning purposes, once the state formally closes their proof, I do anticipate the defense will have a motion.
All right, I understand that. All right, then, ladies and gentlemen, we'll take a recess to allow the state to review the draft of our charge, and then we will go come back in as soon as you're ready on that when the jury arrives. If there's any issue, if there's no issue, please let us know so that we can get these all printed, all right? Thank you. We'll stand at recess.
All right. This court's in recess.